Meanwhile, lawyers for both the state and the lawyers engaged in serious arguments regarding the lawyers appearing for the KMPDU officials sought to have the 1-month jail term reviewed, accusing the government of not being keen to resolve the strike. On the other hand, the lawyers appearing for the government wanted the contempt case dealt with without delay.
Order number 3 reads that this honorable court hereby directs that the dispute be subjected to an inclusive process of negotiating to resolve any outstanding issues arising from the collective bargaining agreement dated 27th June 2016 in such a manner and within such timelines as this honorable court will direct.
Let's go on.
That is the order of the 1st December but issued on the 2nd in the lead. And that is the order that...
that is order number 3.
Yes.
There is order number 1 and 2 also.
Yes, but we are demonstrating our compliance with that particular direction of negotiating with the parties.
Okay.
So, my lady, indeed, the parties did proceed from those minutes to break down or to sort of unpack that CBA in compliance with that order and proceeded to examine the CBA point by point, and it is captured or article by article as it were, and it is captured in those minutes.
The order on 2486 and 2479 which has been consolidated.
24, 2 files.
The suit filed by Moy Teaching Referral Hospital has an order on the same day. And this is my view, maybe, in an attempt to persuade you to review your order. The court suspended the strike for 30 days but issued yet another direction. That is the portion, my lady, I would plead with you today to issue directions and review your order. This court hereby directs that the dispute be subjected to an inclusive process of negotiations to resolve any outstanding issues within such guidelines as this court will direct. I've looked at all the orders issued subsequently, no such directions I can offer. And let me tell you, because I've been, these officials entrusted me to be their coffee analyst, so I've been doing the shuttle diplomacy between them.
Which document are you referring? Is it a judgment or a ruling?
Order.
The order of which date?
1st December. There are 2 orders.
Okay, you are referring to the order of the
Yes.
first. Yeah.
I'm simply saying that in my shuttle diplomacy between the officials and the cabinet secretary, the frustration has been that there does not appear to be something that will make the other party or the other side sit on the table and agree. And the reason is that had you issued guidelines and timelines so that the doctors cease their strike and the ministry then completes these negotiations as proposed in this order, maybe we will not be here.
It is our humble submission that the application does not meet the threshold for review set out under Section 16 of the Employment and Labour Relations Act and Rule 33 of the Employment and Labour Relations Rules 2016.
Rule 32?
Rule 33. My lady, the grounds for review are very clear. And my lady, you are not being told to review the orders because the applicants have discovered any new evidence or there is any mistake or error apparent on the record or the judgment requires clarification. My lady, the court orders were very clear and the applicants were found to be in contempt of court. Up to date, they have not found that contempt. And my lady, actually they do not have a right of audience before this court. My lady, our second ground is that the application cannot meet the thresholds for review because, my lady, under Rule 33, you can only review if you have not appealed. And it is very clear. My lady, the applicants have already filed an appeal, being appeal number 9 of 2017.
That's right.
The Council of Governors, argued this on the 12th of January, came before this court because of a document referred to as a CDA. Now that is not the reason why the Council of Governors came. The 1st of December last year, 2016, the Council of Governors approached this court. And this is the issue we need to focus on, not side shots. The Council of Governors approached this honorable court because there was an impending strike action. And who was the party? The party intending to strike was a party offering essential services. Essential services as outlined in the Labor Relations Act, Section 81, is a service where strike is not something that should just be declared and handled casually by the officials. We have done that this time. It's an essential service well spelled out under Schedule 4. And we were apprehensive, the client was apprehensive of the magnitude of suffering that will occur and that we have seen occurring for 77 days on.